Have another call on the line, Ashley, with a will question. Go ahead with your question, Ashley.
The question is my father has a will. It has been notarized, but do you need, like, say, a lawyer or anything like that in order to show representation of the will to make sure it's given correctly, or can the person who's listed as beneficiary be the person to take care of it?
It's actually a great question, because a lot of times individuals assume that they can make up their own will, and they have been unfortunate to go to some of the box stores, is what we call them, and get a form that is drafted, and they think that that is their will. And there are some requirements to have a will validated and accepted by the court. Now, Chad, I'll let you jump into that, because I think what Ashley was talking about, it actually has been notarized, but there are also some few other requirements as well for that will to be valid.
Yeah, absolutely. So, interestingly enough, there's a big misconception in Florida. The will doesn't even have to be notarized.
Okay.
It has to have two witnesses and the person who signed it, the creator of that will, that what we call the testator. That's the requirement, right? We have to have the person making the will sign it, and we have to have him sign in front of two witnesses who also witnessed each other signing that will. So if you have that, if you have a document that has at least the creator of the will signature and those two witness signatures, it then can be, sent to the court, the probate court, whenever that person passes away. My advice, though, if you're wondering, if you have concerns about whether the will is legitimate or has any formality issues when it was created, seek out a lawyer, have them take a look at it. If there is something that needs to be fixed, you can have that fixed by that lawyer at that time.
Now, Chad, one of the things that Ashley was assuming, or I guess asking, and I'm going to just assume to go one step further, can she turn that will into the court, so to speak? And of course, you can file that with the court. The problem is what you're going to run into, Ashley, is the old saying, don't go at it alone. The person that represents himself has a fool for a client. A lot of times, when you get into probate issues and estate issues, you're dealing with a specialty area of the law that requires someone who actually knows what they're doing and does this all the time.
Yeah.
So, i.e. someone like
Absolutely.
Chad, okay? They know the nuances of the ins and outs of what the court will accept and what they don't accept, and the testate rules and intestate rules. If you try to do this yourself, a lot of times you can bungle things up and really make a mess of it. And so I would advise you to err on the side of caution. Yes, you're more than welcome to submit your will and file that with the court. But along with that, do you have your death certificate? Do you have the notifications that need to go out to any type of heirs or beneficiaries? And who's going to be the personal representative, and who's going to prepare those forms? So it's always easier to spend a little bit of money, get the attorney involved, and at this point, since a will has already been drafted, get them to administer the probate of your estate, and it will take a lot of headache away from you, and aggravation and uncertainty, really.
Yeah.
Chad, we talk about wills, okay? And we kind of hit a little bit about trust. Now, trust can be very complex, so we could spend hours talking about trust.
That's right.
But what is a trust?
So, in the simplest of terms, a trust is a document that you create, that you retitle your assets in, and therefore, the primary purpose is to keep your assets from going through probate, right? So, for instance, if you were to have a trust, you put your house in your trust, when you pass away, that house does not go through probate. I mean, that's the tip of the iceberg. There's a lot of other benefits to a trust, and some of those would be if you have minor beneficiaries, if you have beneficiaries who you're concerned about who can't manage money for themselves. You can implement provisions in that trust document to protect those beneficiaries from themselves. But primarily, you think of it as a document that you create to make sure your assets don't go through probate.
So just take it one step further. When you have a will and you file that with the court, that's the roadmap and the instructions for the court to do what the decedent has asked the court to do, or his last wishes, or her last wishes. When you have a trust, that's more along the lines of you've parked some assets over into not a vehicle, so to speak, but you've parked it over into an entity.
Yep.
So when you pass away, the court does not even have any say-so over that trust normally. And those assets would pass through the trust to its named beneficiaries. Is that a simple way of looking at it?
That's a great way to look at it. And the person who is in charge of that trust is called is the trustee. And so that trustee it's what I always like to say. It's your inner circle, right? That's the cool thing about a trust. You don't have to worry about a court getting involved, aside from some type of contest to the trust. But, you keep it within your inner circle. You make sure the people that you love and trust are managing, no pun intended, are managing your assets for your beneficiaries. And then, make sure that your wishes are followed.
Right.